Today we have, it's a very special session. We have Mr. Jatin Popat himself from Willjini. Willjini is one of India's most reputed companies when it comes to will planning, inheritance planning, will making. We couldn't have been more happy and more privileged to have Mr. Popat and his team here. All of you know about Sukoon, so I'm going to keep introduction about Sukoon a little towards the end, but I'm going to hand over the conversation to Ajita ma'am and Jatin sir. Ajita ma'am is our very beloved Sarthi on Sukoon. Sukoon is the entire concept of Sukoon is to get connections and conversations going between seniors pan India. And on this platform, we have these awesome seniors whom we call our Sarthis. Ajita ma'am has been a Sukum Sarthi since the day one of our company's journey. She will be co-hosting this session with Jatin sir. Over to both of you.
Thank you, Vibha. Thank you so
Vibha.
much. Yeah. So good evening, everyone, and thank you for joining us today. It's a wonderful evening here, and I would like to specially welcome our guest of honor today, Mr. Popat. Thank you so much, sir, for joining us today.
Thank you, Ajita.
And sparing some time from your very busy schedule. We really appreciate. Thank you, sir. Okay, so I'll start it is a question and answer format. This is for the information of the viewers, but hang in there with your questions because the platform will be open for viewers and participants at the end of this question and answer session. And you can ask your queries to Mr. Popat, okay? So shall we start, Mr. Popat?
Yeah, sure, Ajita. Thank you so much for the session. Let's go ahead.
Yes. So, probably 50 years back, no one would think of creating or drafting a will. Everything was just taken for granted. Inheritance was just taken for granted. Why has will making become very relevant and important, shall I say, today?
Yeah, Ajita, I think it's more relevant to understand the importance in today's world, right?
Yes.
So the inverted comma is today. So let me give you a very quick background. The Hindu Succession Act came in India in 1956, right? 1925, Indian Succession Act, Hindu Succession, all the about the 75 years back. If you see that the Indian culture from the Ramayana or Mahabharata time till the till the 100 years back, all this period, we had a practice or customs or whatever you can tradition that the senior member of the family will decide who will take over the lead of the family's wealth and the businesses or whatever, and they will take care of the family, right? So the scenario was somewhere it was tradition and culture where things was given it to the one of the person will be senior most and they will take care. For example, in Ramayana, Lord Ram was to be given the whole thing, and then there was a Ramayana came in place because of the inheritance or whatever you can call. All these things have been followed by the Indians in a very tight cultural ways. That everything was managed by the family seniors. Whatever they say will follow. But those following thing to our tradition culture nowadays is being challenged by the modern world. People is asking why not me? And then the law comes into picture. So the tradition is gone, now the law in picture. So law says, okay, if father is no more or a mother is no more, the wealth should go to the legal heirs. Now legal heirs via will or via law. So the question of law has started coming in. So that is the more relevant today, that if the current generation is questioning on the parents' rights on giving it to somebody Earlier, it was a tradition. Automatically, it will goes to husband to wife and wife to senior most son and whatever. But today, it is not. Today, one has to decide, put it in piece of paper that whom they want to give to what, and then they will follow. That is why this writing we call it a will, right? So I think I'm making a sense, right? So
Yes, yes.
today the money is becoming more powerful than the tradition, relations or a culture or whatever. That is the reason that today it is the time has changed. That's the only message I want to give.
Yeah. Thank you, sir, for putting it so well. Probably, earlier patriarchy was also a big thing, and, it was automatically given to the eldest son or whatever it is. And I think in a way it's good, isn't it? That it is being documented and wills and testaments have come into play. I understand you told me about money being more important than relations, but I guess that is the way forward.
Yeah, I think good or bad, let people decide. But this is the fact of the life
Okay.
that whatever is there, we have to follow the what current tradition is.
Yes.
Today, if the siblings are not that bonded than the earlier days,
Hmm.
right? We all know, right?
Yes, yes.
Earlier, it was not like that. Everyone earlier, elder brother is saying something, everybody will follow,
मानते
or
थे
sister,
हाँ
whatever. Nine.
correct
अभी तो I think people says नहीं ऐसा क्यों मुझे मेरा
ऐसा
हक
क्यों
चाहिए.
correct
Right?
correct correct I also will want to take up that word you used about Hindus. So basically is it different for each religion? uh,
Correct. So in
will
India,
and testament,
yeah,
yes.
correct. So in India,
Hmm.
if you don't make a will,
Hmm.
if you don't make a will, so
Hmm.
I'm saying India, the Hindu, Christian, Parsi, Muslim,
Hmm.
all the religions, Sikh, all the religions are there. Okay. Indian inheritance is based on the personal law, number one. Okay. But that personal law will come into place when you have not made a will. So, if you made a will, everybody will have to follow that will, except the people who are following Muslim religion, where they have right to write a will for one third of the property, and two third is being given it to the family as per the Sharia law. So there, in Muslim community, the Sharia law is prevalent all over the world, which is everybody is to follow. But all the non-Muslims, Indian, they have the law of inheritance, and that comes into place only if you have not made a will. If you made a will, whatever you mentioned, it is to be followed by the family, by the government of India, everybody. But if you don't, then Hindu has to follow the Hindu Succession Act, which Hindu include Sikh, Jain also, and Buddhism also, and Parsi and Christian is a separate law. So they have to follow Indian Succession Act. So these are the law will come into place if you don't make a will.
I understood. Yes, yes. So, also, will making seems to be a very daunting experience. There is a legal language. You have to hire lawyer, which is probably not very easy for a middle class family. It is expensive, no, sir. So, what does one do under these circumstances? Is there any way out?
So technically speaking, there is no such embargo on a will document.
Hmm.
The law is very simple that you should make your wishes on a piece of paper, right?
Hmm.
So if I tell you in that way,
Hmm.
one will understand differently. Each
Hmm.
person will understand it differently.
Hmm.
So the legal professional will come in place to explain you what and how you should write, right? So this is a simpler document where one is mentioning about self, about the family, about the wealth or properties they have got, whom they want to give, how they want to give. All these things they are writing. It could be a two-pager or 10-pager, whatever properties they have got. It is simpler exercise. But if you add somebody who has some knowledge and background, they will put it in a way that it is not contradicting, it is not being challenged later on by within the family about the misunderstanding, misinterpretation, and all. So basically, you are trying to take a help for a proper, simpler way, but it has to be covering the legal points as well as it covers it avoids the misinterpretation. So expensive or not expensive again is a subjective. Like for example, our company Willjini is doing online will at 3,000, 5,000 rupees, where people can do it online by putting some information and they get a will document. The lawyer, if they want from our office, we charge 10,000 or something. So that's a fixed cost. We don't have anything connecting to the wealth size, right? Some of the professionals, they try to understand more into the family wealth and all. Maybe they charge fees according to their norms by looking at the wealth and all. But that are all the different professionals, different way they approach. But it's not that complicated for one to spend so much. It's a simpler. Viljini has a tagline: "Succession simplified." So we are trying to simplify the things which are not being understood well by the layman, and we also have a very fixed cost type of process.
Okay. Yes, sir. Thank you for explaining. So it is, I think viewers, what he's trying to say is it's well worth it, and we should make a will at the earliest. So who should be making who should be making a will, and when is the correct time to make the will?
So these questions comes from us in various ways.
Mhm.
So there are different parameters. Somebody is saying, I am holding only one fixed deposit of 5 lakhs rupees. So should I make a will? So wealth size. So wealth size is not a concern. Somebody is holding even a single FD or a 5 lakhs rupees or some bank account, or one property, two property, whatever. When they leave it here, who should use it? So whether it's a one property or 20 property or 100 property, you have to at least pass on to somebody with the writing. Then they become the owner. So wealth size is not an issue. Whichever is the wealth size, whether it's a 2 lakhs rupees or 200 crore rupees or 2,000 crore, everybody has to write it. That's a wealth side. Secondly, the age. When the age, which age you have to write. So unfortunately, I think we all don't know the date of expiry, right?
Yes.
So as soon as we have some wealth, we should write a will, right?
Okay.
So normally people with the age of 40, where they've got some wealth, some investments, they've got a family, they're married, they've got kids, one house. So these are the people, they start thinking on writing a will. And in India, these things have started coming awful very late. But in developed country, this is there for last 20, 30 years. And there is a way they write. Everybody have made will, right? Just like a medical policy, they also write will and they review every 2 years. So that's a practice there. They don't link with the size of the asset, the age of the person. They just make it as a procedure, as a planning.
Yeah. Thank you, sir, for clarifying that. So is there any emergency will, suppose someone is dying or something, is there an emergency contingent will making process that will be accepted and, by the government and everybody?
No, I think only that facility is available for the soldiers on the war.
Oh,
So when they
okay.
are on war front,
Hmm.
they can orally tell to somebody that my wealth will be given to so and so, and that is accepted in the India. They are the only people who can make last wishes on a war front.
Okay,
Rest
okay.
all have to make a will with their proper health and mental capabilities. So we have seen many people, they are on deathbeds, they are on to some medication of neurology, somebody is on the stroke on the mental abilities. So if they write a will, it can be challengeable. So people who in the good health and good sense, without any coercion or force, they should write a will. Many a time it happens that people have crossed 65, 70, and they are dependent on some family member, and they are emotionally being taken for granted, and they have to write everything to them. So all these things can be avoided when person is fit and fine, stay 50, 55, 60 years. when they have control on their total senses, they have got control on their decisions. They should write a will. That is the right way.
Thank you, sir. It is really very important message that you have given us, because sometimes we keep postponing will making, we say ki it is it is something that is not pleasant. It is definitely not a pleasant task. And so we keep postponing it. What about estate planning? Is it the same thing? I mean, how do you estate plan, and, is it different from writing a will?
Yeah. So, yes, you first you said about the people are postponing. Yes,
Yes.
there are people who are postponing the things. Maybe with the reason they are saying that, okay, I am not so old, number one. So the answer is there is no date of expiry. Some people say I may die if I write a will. So we ask them that you have taken life insurance at the age of 30 years. That is also connecting to life, death. And today you are coming back with the argument just to avoid. People spend days, hours, weeks, years for a job and career and everything, but they don't spend few hours, couple of hours for writing a will. So that's also a very sad for the Indians that we have. People say out of nomination, joint will, all this joint everything, but they don't understand the concept and they don't do it correctly. The estate planning is a slightly bigger exercise. We have seen people with the asset size is little bigger and the complex ownership. Some people are owning the business. Some people have got multiple properties which is given it to family members' name. Businesses are in family members' name. There are some asset outside India. There are some the investments are complex. So those type of things require actually estate planning where everything has to be understood well. And so in India, you may be knowing that no person during the career एक प्रॉपर्टी लिया है वाइफ के नाम पे लिया है वन बिजनेस चालू किया है बच्चों के नाम पे चालू किया है एंड देन एट द एंड व्हेन दे राइटिंग अ विल और सक्सेशन दिस ये सब मेरा है अरे आपका नहीं है इट इज ऑलरेडी गिवन टू समबडी नाउ यू कांट टेल योरसेल्फ and that time is the estate planning comes in picture that we have to do the gift deed, the family settlement, so that everything the person who has earned and he has given it to family, they can take it back and make a complete no succession. Otherwise, as soon as you buy a property in a spouse name, she or he become the owner. So you can't say that it's mine, even though you spend money. Some businesses you invested, which are or some shares you have taken, some demat account with the jointly with daughter or son. All this thing really is a trouble-making thing, which people don't know much. But at the end, when they write a will and then this is mera hai, अरे नहीं आपका नहीं है, आप you have to do the reversal process first to claim the in your name and then you distribute. So so these are the typical cases where wealth size or a business complexity or the title ownership are there, where it requires estate planning, where a lawyer, a tax person, or a company secretary, we sit down and then we try to do elaborate exercise, and then we prepare will or a family trust or a gift deed or a family settlement deed. All these things will come. Normally, family trusts are the best thing that people are doing nowadays in estate planning for the larger asset base, where no assets are being securely given it to the trust and it is immediately given it to the family.
Thank you, sir. Thank you for clarifying that and simplifying the term estate planning for me. So my kids are living abroad, and I don't think they plan to come back. So how do I do my estate planning, or how should I plan my will?
Right. So there are three aspects there. Whether your kid's going to be coming back to India in future anytime to resettle, or which country they are working right now, or they are doing a business or job. Because some of the countries in out of the total countries, I think they don't have inheritance tax. Otherwise, rest of the countries here is having the inheritance tax on the succession. So if somebody dies In India, somebody dies and property is given to family, there is no tax. In US, those taxes are maybe 50%. In UK, it's also again 30-35%. In France, it is 50%. In Japan, it is more. So there are various countries, there are taxes they levy on a death. Some countries call it a death tax. Okay. So that type of estate tax, succession tax, inheritance tax, that tax is a levy by the government there on the transfer of the asset from the one person to another because of death. So to avoid those taxes, which is really huge on your hard-earned money, you have to plan in a way that we create a family trust in India. We transfer everything in their name, so it doesn't given it to them there, because by transferring to them, they will have to take it to in their country. So sending money also is difficult in because of FEMA regulation and tax. Secondly, that country will levy inheritance tax. So those taxation is a really big issue, which we can resolve by creating a family trust in India, so that money is put it in there and they can enjoy the income out of it whenever they need. So no, sometimes they say keep it in India, let it grow, because India is also no growing very fast. The returns are the best in the world. So let it be here, but don't put it in my name or our name. You continue to put it in a trust name, so that they earn regularly, and whenever they want back money, they can take it into their country in future.
Yeah.
So no, that will avoid the taxation issue. That will avoid the remittance issue. All these things can be easily been tackled.
The trust, very, very useful information, sir, that you have given us. Very useful. Suppose halfway through, I mean, after making a will, I feel like changing it. What is the procedure? I mean, is it possible?
Yeah. So it is like, if you have one or two changes coming up, then you can do a codicil. That is a
Mm.
supplementary will. That one pager you
Okay.
can just say that I have given this flat to my ex-son. Now I have to give it to my wife daughter. So if there is a one change, then you can do a codicil. If you want to change a major portion, or you don't want to do confuse on when will and codicil, it is better to write a fresh will. So normally, uh, every 3 years, people normally write a fresh will,
Oh.
because of the changes happening in the family members, changes happening in the wealth size, changes happening into the thoughts that whom to give what. So any changes, people can review it 3 years. If there is a change, they should make a fresh will, or they should wait for any further year if any changes are there. Okay, so 3 to 5 years is the timeline where people have to review and give it to them. Right?
So,
So Esther,
yes, sir.
the one more thing, the family trust, as I mentioned,
Hmm.
are also being good for various type of people. Like, for example, a person which is having a special child.
Hmm.
So those parents, they know that special child will be unable to take or use the money properly. So they create a trust. Sometimes the kids are minor. Sometimes the kids are not yet matured.
Hmm.
So they say that if something happens, they should not take the whole money together. Otherwise, somebody fool them around, or they may lose the money.
Mhm.
So it is better to keep in trust, so they
Mm.
get only income out of it. And after few years, the trust can be dissolved and money can be given to them. So trust also for Muslim religious people, they are creating a trust because it is their wish that they want to give it to the wealth as per their wishes.
Mm.
Sometimes Sharia is restriction they want to avoid, so they create a trust. Some people into business having a large creditors, they also make a trust, so that the trust will protect the assets from the claims of the creditor or a matrimonial issue. So the family trust is for various reasons. Now you wanted to know the question what you asked. Can you just repeat?
I was saying about the same thing, sir, about changing the will.
Yeah,
Is it
correct.
legally accepted once you change? And that you mentioned that
It is
it's
till
better to
yeah.
review your will after 3 years based on the family changes, right?
Legally, one person can make will every day. So till
Hmm.
the time of your life, you are allowed to make any number of wills. The last will be the survived. Okay. So
Yeah.
whatever last will which is made in the proper senses,
Mm.
that will survive. All earlier one will be treated as cancelled.
Yeah, I know that's why they say last will and testament, right?
Correct. Each and every will when we make, we just mention last will.
Last will and testament, yes.
Right.
Sir, also, recently I've been hearing about that Raymond Vijay Pat Singhani. So is, once you make a will and it's implemented also, first, can it be challenged?
So, so there are two things. One, whether the will was made in a right way, right? So one is to take precautions that when you make a will, it has to be made when person is in total senses, mental fitness is there, and there is no coercion or force to them that you have to write in this way or that way. So that's a precondition that one is to take. Secondly, when they write a will, one is to clearly mention what are the wishes and they have to sign in front of two witnesses. Okay. Now the witness also should not be the beneficiary or the related, close related. They should be a neutral party. Could be a long distance relative, friends, relative, peers, professionals, whoever. So those precautions one has to take. One can also take photographs when they sign a will and put it behind.
Okay.
Person with the age of 50, 60, they should always take a doctor certificate to support that they was fit and fine. Okay. Now, that is way of a proper writing a will. You don't have to no contradict within the will, no vagueness. This is a simple step one has to take for protecting this will. Challenging the will is really a task for the legal heirs because when person dies after making such a precautions and proper action is taken, but when the person passes away, the family in whose name the money is to be distributed, when they give it to the family member who are other legal heirs, so they should also agree to this will. Okay, if they say no, this will I am not accepting, I am challenging to it, so the problem goes to the court. That one person says this is the will which was signed in presence of everybody, and it is to be a duty of the government to give it the money to us. The other person will have to prove it that it is an illegal will. So what is happening that once the will is there, the family is known of the wishes, whatever we mentioned in the will. 95% of the family will obey that somebody is passed away. He has signed in front of these two gentlemen or whoever the witness is. They will agree to these terms. Okay. So if there is a will, there is a chances that 95% family they will agree and they will distribute peacefully. 5% people might be they will agitate because of मेरे को कम मिला है मेरे को नहीं दिया है I was told something like this मेरे को नहीं दिया है they may go and challenge in the court of law तो वहां पे वो थोड़ी फाइट होती है and it is one has to prove whether illegal है कि नहीं है but by writing a will 95% at least things will solve so this challenging is a right of any legal heir you cannot say no okay anybody who is a legal heir like for example you might have heard the case law of from the media. Mr. Balasaheb Thackeray, when he passed away, he had made wills, which was about 8, 9 wills he made. So the last will was challenged by the one of the son, and which was contested. So this type of contest happen, and the other party has to prove it that everything. So and eventually, because of the court process, which is long drawn, they finally sit down and settle the matter because of they don't want to wait for the judgment to come. But till that time, the asset may be not to that worth. So many a times when the family members agitate and they challenge, it is really tough for the other party to fight it out because of the court processes. Otherwise, proving the matter by the witnesses, they will come to the court and they say, yes, this was signed in front of us. It becomes proof that will was signed when he was available, will is genuine, and this will is the final will. So those point is proved in the court of law when the will is challenged. Okay. So that part many a times happens when there is a large asset and they have to take a probate. So after the will, the probate sometimes is required for the large asset or the business. So when they apply to the court, the legal heads, everybody will give a consent that they don't challenge. And then that way it will be approved and distribution will happen. So challenging is something which is reality in the world, which nobody can avoid it. But if you make a trust, then those things will completely out of the question because you have already transferred your asset to the trust. So in case of few of the case law that we see today, what you mentioned about the Mr. Singhania's case, he gifted everything to the son. Instead, he might have created a trust so that he can enjoy the wealth during his lifetime. And after his demise, automatically it is given it to the son without going to the court or proving the will. So the family trust is the better way to do it when the wealth size is say about 20 crore and above, or there is a complex assets. Then it is good to create a family trust.
So we are coming back again to the importance of family, creating a family trust. So also I just wanted to ask if a will is being challenged, so will it be frozen? I mean, will the, I mean, procedures be not, I mean, what, be frozen in the sense nobody gets what is their due? Is that
Correct.
how it
Correct.
is?
Correct.
Okay,
Correct. You are right. You are right. So now what is happening that there are nominations and joint account things are there. What is happening that will is made where he has mentioned that everything to be given in this fashion. But during the lifetime, he has created nomination, joint account, and everything. So they will start using those money without waiting for the will, and
Okay.
that is another battle because nomination was given to a wife, and in the will, the name of the son was mentioned for particular property. So there is a clash of these thoughts. So normally, what we suggest to the people that when you write a will, whoever you want to give, please see even nominee also is same, so that there is no contradiction of your will and nomination. Otherwise, nominee will take a money, though they are not supposed to use it, but they will use it, and then this will person who is the main owner legally, he has to go and fight with them. So normally that is why we are saying that will and nominee has to be same.
Okay, all right. So basically, what about digital assets, sir? I mean, so now is the digital, what about all our digital,
So normally will includes what we normally suggest to prepare a will, which include your flats and movable property, your movable assets like your car, your bank account, your demat account, all these things. Then there comes digital asset, which is your Facebook account, your Google Drive, your whatever your Instagram, whatever your pictures in somewhere, your intellectual property like trademark, patent, copyright, all these things, they are part of the will. So digital asset is something one has to claim. If somebody wants to claim, then they should have a legally passwords. Otherwise, each and every company who is having digital asset, they have their own norms. Like for example, Gmail or Yahoo or Amazon, they have their own policies whether they will be allowed to continue or whether they will give it to the next legal heir as per the process, because those are the asset. There is a different rules for them also. So and that are also cross border, like we are, it's not in India, some companies are outside India, so they will follow their law, and that they will say that whether it is allowed or not allowed.
Okay. And estate taxes, I mean, that also is part of, I mean, how do we reduce it and how does it fall in? I mean, what is its relevance in will making?
Ajita, I'm sorry, there was some network issue. I could not hear your question. Can you just repeat?
Yeah, estate taxes, sir. How do we incorporate it into our will and how does it play a part in our will making?
So as I mentioned earlier, the
Mm.
estate tax, which is inheritance tax,
Mm.
which
Mm.
is really a big levy by the government
Mm.
in other countries.
Mm.
In India,
Mm.
there was a humor in last 4 5 years that
Mm.
India also might start the inheritance tax.
Mm. Mm. Mm.
In India, in 1985, the tax was there up
Okay.
to 85. Then it was abolished. So
Mm-hmm.
since 85 till date, there is
Mm.
no inheritance tax or estate tax.
Mm-hmm.
But last few years, we have been hearing the rumors. Even the currently during the election time, there was a statement by Mr. Sham Pitroda and Mr. Rahul Gandhi that they should bring in the 50% type of inheritance tax. So these things are coming up again. So maybe India bring in such taxes. So that could be a very difficult
Yeah.
for the family to
Mm.
pass on even 10%, 15% if they levy. So
Mm.
that's a huge money, right?
Mm.
So many industrial houses, many families, many people have started creating a trust so that those things, if at all future comes up, they can no reduce the liability on that. So that is something for India. But other countries already are levying this type of tax for many years, right?
Okay. Okay.
So whenever there's an asset in India, but you are giving it to somebody abroad,
Mm.
so in that country they will charge the inheritance tax. Okay,
Mm.
so that also is a problem. If you have asset in that country, there also you have to pay a tax.
Pay
So
tax.
so anything where your beneficiaries in that country or your asset in that country, one is to calculate it and start planning now how to reduce the tax burden.
Okay. So the will is confidential. We would like to keep it confident. So which is the best place to store it, or how do we, where do we keep it?
So there are two questions here. One is the confidentiality, other is the custodianship.
Mm.
So confidentiality is something where, say for example, I am writing a will for myself. I don't want to tell to anyone in the world, anyone,
Mm.
right?
Mm.
So even my spouse or my kids or anyone. So the best way is I can't go to even legal professionals because then they will know. If they know my family, they will tell. If the staff know, they will tell somebody.
Mm.
So if I want to do confidentially, we have an online will software. So
Okay.
in Willjini, we have got a software which
Mm.
is which is fully technically encrypted and also no leakage of information. So one can create a will self, do it yourself way by paying 3,000, 5,000 rupees. One can create a will, one can take a print and sign. So that's a confidential way that you don't want to tell to anybody. And so that you can create your own will on your own way. Then the question comes where to store it. So that is called a custodianship, whether you keep it in your home at a cupboard with a important document, or you keep it in the safe deposit locker, or you keep it to one of your friend or executor who is going to help you for distribution. Or companies like us, we also have locker. We take custody of the will and we keep it with ourselves by charging nominal fees, and we give them the certificate that so and so person has made a will and which is kept to us. So and so person can come and take after the demise. So those type of arrangement is there. So it's up to a person where he wants to keep the will, so that see, many a times it may happen that somebody is if you kept it at home or local, they see nothing is there in their name, they will tear it off.
Yeah.
So one has to see that even after the demise, someone should not do wrong with the will. So you have to keep it in a proper way that will come to knowledge of the family, the original will. Right?
Yeah, thank you, sir. I think that kind of sums up my questions. So we will ask the audience to ask questions. I can see that there are a lot of questions in the chat box here. Um,
So,
should the will be registered?
good question. So registration of a will is the only document which is not compulsory. So
Okay.
registration happens in the nearest sub-registrar office where you normally do registration for flat or a power of attorney. It's near to your house, and that is not mandatory. But we normally suggest that if you register a will, the acceptance later on by the banks or the courts it's easier. If you don't register it, some of the authorities, they question the authenticity of the will, and they say you bring a probate. So if it is registered will, that means the person who has signed a will, he is also gone to Government of India's office. Government also witness. So the question on the authenticity is not raised by somebody. It is accepted well. So it's an additional cost. So we have provided these services all India level for a fixed cost, and then that takes about 1 hour time. So registration can be done if it was it is recommended.
It's important. Yeah, yeah. Is the executor essential in a will?
The execution of a will, that means you are giving responsibility. You have got 10, 15, 20 assets, and you have given it to XYZ people. Okay. Now, who will actually do distribution? So you need to have someone who will take a responsibility.
Okay.
Everybody can't come and they say, I will to do, I want to do. So to avoid those type of mismanagement, it is good to appoint one of the person as executor. So it could be from the family members, it could be a professional, it could be any friend. You can appoint anyone. So you are legally appointing a person that you will do distribution. Okay. So if it is outsider, then they may be taken some fees or remuneration for distribution. It's a process which may take 6 months to 1 year time. So somebody has to do properly as per the wishes. And they have to see that if the probate is required, even the executor go to the court and bring the probate. So if you don't write executor name, then all the beneficiary, they will start fighting that I will do this, I will do this. So no, that can be avoided.
So somebody you trust probably is someone
you should trust properly that yes, they at least have a neutral approach. They will not no mismanage the whole asset for their interest. So many people appoint professionals. We are acting as executor with many clients. So they appoint us in advance in the will, and later on we play our role by our team, our lawyers, company secretaries, tax people. We try to transfer the asset expeditiously. If probate is required, we also apply to the court for the probate.
Okay. So the next question is, should the will be discussed with the children?
It's not common with everyone. People do discuss with the family openly. People sometimes they don't do with the reasons. So it's everybody's no personal decision whether because each household has his own story. So depending upon how the children will take it, sometimes if you disclose, you find that some one of the child is started misbehaving or no. So one has to take care on that. To before dying, one should not start feeling like a dying.
So basically, it needn't be 100% confidential. You can, there's a
Absolutely.
question. Can it be read to the family members,
Yes,
immediate
yes, yes.
family
There is no
members?
law. There is no law that it has to be only that confidential. Confidentiality is up to you how much you want to keep.
Okay, okay. So before registering it, you can show it to your family members and say, this is what.
Yeah, we have seen in the Hindi movies and all, no, that lawyer comes at the end and he'll open with the death.
Yes,
All these things are happening also today. With some of the people, they keep it so confidential. It is not even the spouse doesn't know. It is given to third person. He will come and will show.
Yes, I know of a case like that where the spouse was, unpleasant shock she got after, the will. Anyway, is it okay to write a will on a piece of paper and take the signature of two witnesses and not to register it? Just, handwritten will. Is it accepted?
It is accepted, provided you know what you have to write to avoid any confusion for the family. You are writing a will which is maybe worth of 1 crore to 10 crore of your asset.
Correct.
So if you take legal help, it may cost you 3,000, 5,000, 10,000. So you have to decide whether you want to take a risk of those 1 crore, 10 crore, or you want to pay 5,000, 10,000 rupees. So it's up to you to decide.
Yes.